Major breaking news. There is a huge opportunity here for the Donald Trump Department of Justice to vindicate our right to keep and bear arms, specifically when it comes to owning, possessing, and using semi-automatic rifles such as AR-15s. That is the pending petition for cert before the U.S. Supreme Court in the Viramontes versus Cook County case out of the 7th Circuit. We have to talk about this. This is a big deal, folks, and it's time sensitive. Let's talk about it when we come right back. Hey, folks, I'm Mark Smith, host of the Four Box of Diner, proud American, gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice at the Second Amendment in America. Thank you, 2025 Gundies Awards. And by the way, folks, just want to let you know, this weekend I'll be out in Salt Lake City, Utah, talking to the Gun Rights Policy Conference, sponsored by the Second Amendment Foundation. I'll also be speaking at AmCon, talking about the Second Amendment in the media. So if you're going to be out there in Salt Lake City, make sure you stop by and say hello to one of the speaking engagements I'll be doing there for the Second Amendment Foundation and more. All right, folks, this is a big deal. This is a big deal, and I'm using this as an opportunity to flag the issue for the Second Amendment movement because it may have slipped a little bit through the cracks because our Solicitor General's office, our Department of Justice, has been incredibly busy with winning for America and Donald Trump in the U.S. Supreme Court. They got John Sauers like an undefeated record before the U.S. Supreme Court, representing effectively the Trump administration as the Solicitor General. We have Harmeet Dillon and her excellent team over there at the Department of Justice fighting for our rights, and like the Barnett case in the 7th Circuit this week, obviously submitting major briefs in support of the Second Amendment, as well as our right to have AR-15s and magazines in cases like the Cheeseman case, the Association of New Jersey Rifle and Pistol Clubs case there in the 3rd Circuit, which is going to go en banc anytime soon. I think the argument's coming up in a few weeks. And, of course, doing a much better job arguing about suppressors down there in the U.S. Court of Appeals for the 5th Circuit. With that said, there's a huge opportunity that I want to flag, and I'm going to break down how I, as a Supreme Court litigator, think about this important question. So if you want to get geeky at a high level, we are about to do it right here, right now. So I assume that the United States Department of Justice under Donald Trump wants to win for our Second Amendment rights, specifically on a Supreme Court victory, which is what we need in the 2A community, a Supreme Court victory before the Supreme Court that specifically holds that we Americans have a fundamental Second Amendment right to possess semi-automatic rifles such as AR-15s. I'm highly confident that the Department of Justice wants this. And the basis of this is that this is literally what they're arguing and have argued already in the United States Court of Appeals for the 7th Circuit out of Chicago, where Harmeet Dillon made that excellent argument in Chicago just this week in the Barnett case and the related cases. Likewise, the Department of Justice has submitted a powerful brief arguing for the same thing that AR-15 should be protected under the Second Amendment, cannot be banned. They made that exact same argument in the Cheeseman case pending before the United States Court of Appeals for the 3rd Circuit, which is going to be argued in the middle of October. En banc, in fact. Now, listen carefully, folks. We're going to get geeky here, okay? The U.S. Department of Justice, with the Solicitor General John Sauer and the Second Amendment people over there, to me, need to file next week or so, before the deadline, an amicus brief to the United States Supreme Court, urging the Supreme Court to grant cert in the pending case of Veramontes versus the County of Cook, or Cook County, which is in Chicago. This is really important for many reasons. And I want to make sure you understand this, because it's nuanced, but I'm right. Here's the story. If the Supreme Court wants to hear an AR-15 case this term, and if the Solicitor General's office wants the Supreme Court to finally rule once and for all that AR-15s are protected arms under the Second Amendment, cannot be banned in the same way that you can't ban handguns under Heller, which I'm sure DOJ wants, then the proper vehicle for doing so is this Veramontes case right here and right now, because it is pending before the Supreme Court. It's on a petition by Second Amendment rights claimants, meaning the Second Amendment Foundation, I believe, is behind this suit, are the parties. They're the plaintiffs. And they have an excellent group of law firm. They have an excellent law firm, Cooper and Kirk, which everyone knows. They're the big law firm, one of the big law firms out there fighting for our rights every day in the courts, among others, but one of the big ones. And they're Supreme Court litigators. The Supreme Court knows them. They argue cases before the Supreme Court. The court knows them. So there's no issues on that front. But listen carefully, folks. The only case right now that I see where the U.S. Supreme Court can hear a case this term before June of 2026 and ruled in our favor on AR-15s and semi-automatic rifles is this Viramontes case. So that alone should warrant the Department of Justice submitted an amicus brief saying you should hear this case. Number two, the DOJ has already publicly taken the position that AR-15s are protected arms. They did this in the Barnett case in the Seventh Circuit. They did this with Harmeet Dillon's arguments in the Seventh Circuit in oral argument. They did this in the Cheeseman case in the Third Circuit. So to argue that the Supreme Court should take the Veramontes case and argue that AR-15s are protected arms, because the question presented in Veramontes is literally, does Cook County have the right, have the authority under the Second Amendment to ban AR-15s? So it's squarely the issue. Now, we're going to get even more geeky here. Some people have argued, specifically the U.S. Court of Appeals for the Seventh Circuit in the panel decision, they argued in their opinion, rejecting the claim under the Second Amendment in Veramontes. They argued that the record was not adequate as proffered by the Second Amendment claimants. That's what the three-judge panel said. But that's hooey. Why do I say that? Because the Seventh Circuit in the Veramontes case, when it was at the Court of Appeals level, was applying that ridiculous fake legal standard set forth in the Beavis case by the Seventh Circuit, by Judge Frank Easterbrook. So they said, the Seventh Circuit in the Veramontes case at the Court of Appeals level said that the Second Amendment plaintiffs had not done enough to prove that they met this ridiculous Beavis test, this Beavis standard. But who cares? Why do I say that? Because we all understand that the Beavis test is fake law. Fake law. Made up by the Seventh Circuit and Judge Frank Easterbrook. And you don't even have to listen to me say that. Harmeet Dillon, the head of the Civil Rights Division for the Department of Justice for Donald Trump, literally said exactly what I just said to the face of Judge Frank Easterbrook in the three-judge panel in the argument in Barnett this week. And she's correct. The legal standard is under Heller when you're dealing with an arms ban case, because Heller dealt with an arms ban and handguns by DC. You just have to apply Heller, the in common use test. You shift the burden to the government to show that the arm they're banning is not in common use. We're talking about AR-15s and semi-automatic rifles. There's 0% chance that the government can win this case. Period. And keep in mind, the Solicitor General's office under John Sauer and the Department of Justice can argue that they should grant cert in Viramontes. And any suggestion out there that the record is inadequate in the Viramontes case is BS, because when they say the record is inadequate in the Viramontes case, they're not saying that the record is inadequate to satisfy the Heller test, to satisfy Supreme Court precedent. They're saying it's inadequate to satisfy the fake legal standard that's not the law of the land. It's the law in the Seventh Circuit because it was made up by Judge Frank Easterbrook and it's BS in the Beavis case. And again, whenever someone says to you that the record is inadequate in a Second Amendment matter, ask them this. There was no trial record, no experts, no hearing record in Heller. There was no trial expert. There was no trial, no hearing evidence, no witnesses, no expert witnesses, anything in McDonald. Same for Caetano. Same for Bruin. Same for Rahimi. The Supreme Court doesn't need trials. They don't need evidentiary hearings. They don't need testifying experts in Second Amendment cases. The Supreme Court has never, ever, ever, ever needed that or used it, and yet have been able to articulate several major Second Amendment decisions. So when somebody says, like the Seventh Circuit said in this Veramontes case, oh, the record's not adequate, BS. And no one cares what the Seventh Circuit says anyway. We only care about the Supreme Court if you support the Second Amendment, because that is the court that we need to win at, and that is the court we should win at, which is why Justice Brett Kavanaugh literally said in concurring in the denial of cert in the Snopes case a few months ago that this court ought to and is expected to take an AR-15 ban case in the next term or two. Well, here we are in the next term, and the only vehicle is Viramontes. Now, let me get even more geeky. It is clear the Department of Justice, through their actions, have shown support for the Second Amendment in Barnett in the Seventh Circuit and Cheeseman in the Third Circuit, and I applaud them. But ladies and gentlemen, there's a danger there. And I'm identifying this danger, which is why you tune into this channel and not others to get this inside baseball understanding of Supreme Court litigation strategy. Let us assume, for the sake of argument, folks, and I hope this happens, by the way, the Third Circuit en banc decides that indeed the New Jersey ban on AR-15s is unconstitutional and that everyone in New Jersey has the right to an AR-15 semi-automatic rifle. That's the right answer. There's a good chance the Third Circuit's going to rule on that. Likewise, there's an outside chance, I think this is a lower likelihood, but an outside chance that a 2-1 decision could come out in favor of the Second Amendment in the Seventh Circuit out of Chicago case of Barnett, saying that the Illinois law banning AR-15s and magazines are also unconstitutional and cannot be enforced. So it's possible that the DOJ and the Second Amendment claimants could win the New Jersey case in the Third Circuit and could win the Illinois case in the Seventh Circuit. And we'd be like, yay, win, 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 right? Yes. But there is a danger to that. And you're like, Mark, what are you talking about? We just won. What's the danger? And the answer is this. If our side wins the Third Circuit case and the Seventh Circuit case, which is possible, we win both. What does that mean? That means that the anti-gun movement controlling those cases could decide strategically not to seek cert to the Supreme Court. So we will have one in Illinois and we will have one in New Jersey. But when the anti-gunners choose not to seek cert to the Supreme Court, fearing a nationwide loss and a nationwide win for the Second Amendment, which is a nationwide loss for gun control, they may choose to take their lumps and not seek cert, which means that to the extent the Department of Justice and John Sauer want to be the prevailing parties in front of the United States Supreme Court and set forever precedent by the Supreme Court on the AR-15 question, those cases of the Third Circuit Cheeseman case and the Seventh Circuit case of Barnett will not be proper vehicles because they will never get to the Supreme Court because the anti-gunners will not seek cert. Which is why Veramontes is so important, because you have Second Amendment rights claimants in the form of the Second Amendment Foundation, I believe, in front of the Supreme Court with an adequate record to satisfy the Heller test, which is all that matters. And the Solicitor General has already publicly taken the position, the DOJ has already taken the position they support the Second Amendment, support the right to have AR-15s. And I don't think that SG's office needs to write a 50-page book of poetry or a novel or some sort of massive legal brief here. Literally, the amicus brief by the Solicitor General's office in the Department of Justice could simply consist of 3 or 4 pages of saying the following. We agree this issue of banning AR-15s is a major issue. We agree with the rights claimants that this violates the Second Amendment. We agree with Justice Brett Kavanaugh that the court should take one of these cases now or soon. And we think Veramontes is a good vehicle. You've got the right lawyers. You've got the right groups. You've got the right record. You've got everything fine. Take it now and resolve this once and for all. That's all they have to say. The DOJ and John Sauer doesn't have to write some massive document. They simply have to say 4 or 5 pages of, we agree, it's time to take the case. Take the case. Take Viramontes. Now, by the way, to the extent you say to me, is there any historical evidence of the anti-gun movement losing at the Court of Appeals level and refusing to seek cert? The answer is absolutely. Yes, there is. 2 obvious examples. In the case of Wren versus DC, that's W-R-E-N-N, I believe. Wren. In the case of Wren, there was a decision made by the U.S. Court of Appeals for the D.C. Circuit that said there was a right to carry guns, that the right to bear arms means the right to carry guns. This was decided before Bruin. The anti-gunners lost. Did the anti-gunners in the District of Columbia seek cert in the Wren case? No, they did not. They did not. They took their lumps. They lost the case. They allowed for D.C. to become a shall issue permit, and they allowed for their law to be enjoined. They did not want to seek cert because they knew they would lose. Likewise, in the U.S. Court of Appeals for the Seventh Circuit, before Bruen as well, in the case of Moore versus Madigan, I believe that's the name of the case, Moore versus Madigan, the Seventh Circuit ruled that the ban on the carrying of handguns in the state of Illinois was unconstitutional under the Second Amendment. Did the anti-gunners rush to the United States Supreme Court and seek cert, asking the Supreme Court to overturn the decision of the Seventh Circuit? No, they did not. They took their lumps, did not seek cert, and dealt with it. The point is, the anti-gun movement is not stupid. Okay? They do not want to risk losing another case before the Supreme Court if they can avoid it, right? And keep in mind, both the Moore versus Madigan and that Wren case were decided before the Bruen case. So the anti-gunners actually had it right in not seeking cert, because the result ultimately after that was Bruen. And had they sought cert in one of those earlier cases, Bruen would have probably been decided years earlier. But the anti-gunners were smart and they paused and chose not to seek cert. So if the DOJ is successful and they help the Second Amendment rights claimants win in the Third Circuit now and in the Seventh Circuit now, and I hope they do, there's no guarantee that those cases go to the U.S. Supreme Court on cert because the anti-gunners won't seek cert. So as far as I'm concerned, the DOJ and the Solicitor General's office should file a short amicus brief next week before the deadline has come and gone in the Veramontes case, and they'll explain to the Supreme Court, this is a good vehicle, take the case, this is all you need. You know what the legal standard is, which is Heller. You don't have to figure out any intellectual genius stuff because the Supreme Court already set forth the legal standard and the constitutional standard for arms ban cases of Heller. The DOJ already agrees with this. They've already made this case. They've already said AR-15s are protected arms. Everyone understands this. And Justice Brett Kavanaugh literally already wrote the decision, I should say, in his dissenting opinion in the Heller 2 case back in 2011 or so. So the point is, DOJ, John Sauer, needs to file an amicus brief and support the cert petition in the Viramontes case. That's my opinion. This is why I think about it. This is the way I think about it. And I should also say that don't come at me and say, you've got that Miller case out there in the Ninth Circuit, because somebody may say you've got like the Miller versus Bonta case dealing with the AR-15 ban in California. Do you know when that was argued, folks? That case was argued in front of an absolutely terrible Second Amendment panel in January 2024. January 2024. 3-judge panel of terrible judges going to rule against the Second Amendment 1,000% in that Miller case. And we don't have a decision because the anti-gun judges are playing the game because when you're an anti-gunner, whether you wear a black robe or a suit or a red shirt, it doesn't matter. You all want the same thing, which is the end result of gun control in America to be sustained and the Second Amendment to be destroyed. And again, the cleanest way to win the AR-15 case at the Supreme Court and set the national standard once and for all, which if the court takes this case, we're going to win it. We're going to win the AR-15 case at the Supreme Court. We just need them to take it. They should take Veramontes. And to the extent the DOJ is like, hey, why don't we wait for Cheeseman or these other cases like Barnett to percolate up? That may never occur. So I'm only bringing this to everyone's attention because I know DOJ has been so busy doing a fantastic job with the Trump administration and winning. But this is the kind of thing that I want to make sure doesn't slip through the cracks. And again, y'all can let me know if I'm missing some point, if there's some observation I got wrong. But this is how I see it. And again, I welcome comments, criticisms, and attacks from all quarters as appropriate. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at Four Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble. And I'll talk to you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.